What's up, everybody? A much requested video here about Taylor Schabusiness, the wild trial that is going on right now. We're going to talk a little bit about that trial. We're going to play part of the defense's or most of the defense's opening statement to help us understand this whole deal about two different pleas, not guilty and not guilty by reason of insanity, two phases of trial, two separate trials, different rules than we've seen in some other cases. We're going to talk about how different or similar it is to some other states and other cases or things that we've dealt with, how it works, why it's set up like this, what the prosecutor has to prove, what the defense has admitted to or not admitted to, and how they are going to fight a case like this. So if you are interested in one of the people that asked me about this or want to know this answer, have been watching this case, hit that like button for me and throw your question in the comment. I'm going to maybe do one other video, maybe more than one on this trial. I'm not going to do daily recaps. The details are gory. I don't think this first phase is going to be particularly intriguing or have any novel arguments. This looks like it is pointing towards guilty and a big loss for Taylor Schabusiness in at least phase one, the guilt phase of this trial, to which she has pled not guilty. 3 charges are ending someone's life, dismembering them, and then some abuse with some toys and things like that post death for the victim in this case. Those are the charges that the state is alleging and trying to prove in this case. And this centers around, let's see if I can give the least graphic version of this. But Taylor Schabusiness was hanging out with the victim and they were in his basement of his mom's house. She's the last person seen with them. People knew they were hanging out together. Mom comes home, pulls a towel off of a bucket and sees a part she can recognize of her son. And her mom's boyfriend is also there. He sees it. Turns out knives were used from the house to dismember the son. He was deceased, and she did things after, like I said, with toys and whatever to abuse the body further. Those are the allegations. And she has pled not guilty to the crime, meaning I did not do it, or the state cannot prove that I did this. And then she has also pled not guilty by reason of insanity. Now, in most cases, you have to admit that you committed the crime charged in order to plead not guilty by reason of insanity or some kind of mental incapacity that did not allow you to commit the crime. Well, in Wisconsin, they allow you to plead both ways, not guilty and not guilty by reason of insanity, and they split it into 2 different trials. The first trial is the guilt phase, and the state has to prove beyond a reasonable doubt that the defendant committed these crimes. And the defense can argue they didn't do it, or the state can't prove that they did it. And then if the state wins there, it goes into phase number 2, where there is a trial as to whether or not she was legally insane, meaning she didn't understand what she was doing. She didn't understand that it was wrong. She didn't understand the consequences of her actions. Similar definitions to insanity we've seen in other cases. That is a separate trial. Now, what's interesting to me is part of this makes sense, because if you really are legally insane, you don't know what you're doing at the time of the crime, then how can you admit that you did it? Maybe somebody can convince you after, or there's a video or pictures, or you put the pieces together to realize you did it, even though you blacked out or didn't understand what was going on at the time of the crime. But part of it makes sense to say, okay, state, first prove that I did it. Once you prove that I did it, I'm going to prove I was insane because I don't even remember what I did at the time. So part of that makes a little bit of sense. But it's very interesting to hear a defense's argument to this. And the state, I thought in their opening statement, both the opening statements were very short, 10 to 15 minutes. The judge limited them to 30 minutes, which is fine in a not the most complex guilt phase or factual case that they have without all the medical information. And I thought the state did a really good job of laying it out, not over sensationalizing it, but it was very sad and graphic and hit all the points and made you think, okay, they're going to present why this was Taylor Schabusiness who did this. And so we'll say, okay, what's the defense's argument? What's their defense going to be in this case? It seems like they have so much evidence against her. It seems like this could only point to her. So we are going to watch a good chunk of the defense. But keep in mind that they have pled not guilty by reason of insanity, secondarily, and we are eventually going to hear that argument. But first, the judge does not allow them to put forth that argument in this phase. Okay. And that's where it kind of gets complicated. So they can't argue diminished mental capacity. They can't argue she was insane at this point. They just have to say it either wasn't her or the state can't prove it was her. That has to be their arguments at this point in phase one of the trial. Now we're going to go through a lot of this, and I'm going to really dig into what these two pleas mean and what the difference is after we watch this opening statement together and discuss kind of how the evidence is coming out so far in the trial. Because we get a good idea of what is the defense, what is the defense's argument. We get our first idea here in opening, and then more when I tell you kind of how the witnesses are going as a broad kind of picture of how it's going so far for the defense. So let's listen in to the opening statement.
Our court system simply couldn't function. The lawyers couldn't do their job, and the court couldn't do its
He's just thanking them for their service.
So we appreciate your time, your attention to detail, and your anticipated focus over the next several days that you're going to put into this very serious case. Now, in this case, the state of Wisconsin, through the Brown County District Attorney's Office, has the complete burden of proof. The state must prove to all of you jurors, beyond a reasonable doubt, each and every element of the crimes charged beyond a reasonable doubt. The United States Constitution presumes that every person who is accused of a crime is presumed to be innocent. And in this case, Taylor Schabusiness is presumed to be innocent. She doesn't have to prove anything. The defense does not have to prove anything in this case. Why? Because the complete burden of proof rests with the District Attorney's Office, with the state of Wisconsin. They have to prove up all the facts. And in this case, you're going to hear a lot of different facts. You're going to hear a lot of different accounts from witnesses, citizen witnesses, detectives, police officers, experts, DNA analysts, medical examiners, all of that. You're going to have to take all of that information into consideration when you deliberate.
So he starts out, presumption of innocence and burden held by the state. They've got the big burden here, beyond a reasonable doubt. We get it. It's important. Presumption of innocence, very important. But those are vague defenses that every defendant has. That's not specific to this case. It doesn't tell us how it's going to be difficult for them to prove this case specifically. Usually that's connected to a bad investigation or a non-credible witness, or there's just no evidence in this case. You connect that type of stuff, usually those arguments. But he's kind of like broad brush painting here so far about his client, and we're starting to understand that maybe there is no defense, but let's keep listening.
But the entire burden rests with the state in this case. My client, Taylor Denise Schabusiness, also has an absolute right to remain silent. Under the law, she has a right not to testify if she so chooses. And if she elects not to testify, you cannot use that fact alone against her in this trial.
Another right. She has a right to remain silent. Don't hold it against her. You could say that about literally any defendant at this point.
She doesn't have to testify, but she may testify. In this particular case, ladies and gentlemen, Taylor Denise Schabusiness was friends with Shad. They went to high school together. They went to school at Bayport, and they had classes together. And they were, when they were younger, they dated for a short period of time. But basically, they were friends. You're going to hear some testimony on, it was Wednesday, February 23rd of 2022. You're going to hear, I believe, a 911 tape. You're going to hear testimony from Tara Pakinich and Stephen Hendricks. They live at 829 Stony Brook Lane in Green Bay. There was a call from Mr. Hendricks that he apparently went downstairs in the basement and saw a bucket, saw a human head in the bucket.
So again, he starts laying out what the evidence is going to show. Witnesses, what they see. Doesn't seem like they're disputing it. 911 calls, which we hear. Law enforcement body cam footage, which we see. Doesn't sound like he's disputing any of that.
He checked it out because his significant other, Tara Pakinich, had initially went down there and saw this and had him go check. He didn't have glasses on, but he apparently called 911, and that caused the officers to come to the scene at 829 Stony Brook Lane. And there'll be some testimony about this residence. It's a small, quaint home. It's got a loft upstairs where I believe Tara Pakinich and Stephen Hendricks were sleeping. It has a floor level with a kitchen, living area, and then it has a basement. And there'll be testimony. We believe that Stephen Hendricks last saw Shad at the house on Monday night, which I believe would have been February 21st of 2022. He will indicate that both of them will indicate that they really did not see Taylor Schabusiness leave. They heard a vehicle start, a door slam, caused them to wake up. Officer Wanish, you'll hear from him. He came to the house and went down the basement to make some observations that the officers did.
So we have a description of the house, the people there, what they heard, what the evidence is going to show by the prosecution.
A protective sweep. They walked around the basement and the entire house to see if there were any other people there on February 23rd, 2022. And the only people that were there were Tara Pakinich, the owner, Stephen Hendricks, and daughter Ava Wheelock. Those people were there.
So there's the first actual argument we're getting. Taylor Schabusiness was not there when they went and found the parts and figured out that something had happened. They heard the door slam and the car drive away. She was the last person seen with him, but when they went down there, she wasn't there. And this is what they're kind of going to weave into their cross-examination. We'll talk about whether or not you think that's strong or weak. It's pretty weak, in my opinion.
No Taylor Schabusiness was there. She wasn't in the basement. She wasn't anywhere in the house. But obviously there was some investigation and evidence was apparently found. And it's true that law enforcement officers didn't have a clear picture or a clear understanding of what was really happening or what happened. And so they're trying to figure things out as they went along. There would be some testimony from other officers with regards to the other scene, which is 2353 Eastman Avenue in Green Bay. That I submit was Taylor Schabusiness's apartment. And she lived there with Scott Thoms, Thoms. And law enforcement officers came over there, and my client came out of the apartment complex.
So Scott Thoms is the guy that owns the van that some of the body parts were found in. So is he going to try to blame it on him? I mean, again, she wasn't there when they came down there so far is the big defense that they have so far. So the fact that she left.
Complex and she was arrested. She had a warrant. She was taken into a squad car and taken down to the Green Bay Police Department for questioning by Detective Groff and Detective Kevin Kempf. Also, law enforcement arrested.
And she makes a confession and leads law enforcement to body parts that they couldn't find yet, that they end up finding. She admits that she kind of enjoyed while she was doing it. Those are all things that are going to come out throughout the trial, is her statements, what she said, how she described it. That's how the prosecutor plans on proving intent, which they do have to prove. In this phase, they have to prove all of the elements of all three crimes charged, that she did it, premeditated, with the results that happened with the medical examiner, things like that. So they're still going to have to do that through this guilt phase.
The other person in apartment one, that was Taylor's apartment, Scott Thoms. He was ordered to lay on the ground, and he was taken into custody as well. You'll hear from lots of different officers, in this case, law enforcement officers. The officers found a gold Chrysler Town and Country minivan, I believe 2006, and they found it parked in the Eastman Avenue parking lot, and there were some concerns about it. Now, this vehicle is owned by Scott Thoms, and I believe that will come out that he was the one that owned that vehicle. But inside that vehicle, there was a crock pot box, and there were some human body parts in there. In this particular case, you'll also hear from Dr. Tranchita. He's the medical examiner.
So again, they admit there are body parts in that van.
A lot of investigative work, looking at cause and manner of death of the deceased. So you'll hear about all of his findings. You're also going to hear from Kevin Scott. He's the DNA analyst for the state of Wisconsin Crime Lab. And his testimony, I believe, will show that he took various swabs as part of the DNA analysis, and items were swabbed. There was sweatpants, there were blades, there were light switch, there was boxes, hands, people's mouths, and a dildo, because that was found. The swab of the dildo, he will testify, I believe, that the possible contribution of DNA from Shadtherian as it relates to the dildo is inconclusive due to the complexity of the mixture. So the state is going to argue.
Yes, he's talking about sex toys because that is part of this case and the gruesome nature and disgusting things that happened that she's been accused of. The jury's going to hear it. I don't know why he's deciding to mention it, I guess, because he's thinking the DNA testing was inconclusive on the sex toys. That's the defense they have. In some inconclusive DNA testing, because there were injuries on her hands, and they are going to find a lot of DNA and parts and blood in places that she was, in cars that she was there, in the basement where she was there. But their defense basically at this point is she wasn't there when they came downstairs and found the parts initially, and then some inconclusive DNA on pieces of evidence in this case.
That there was a sexual assault by use of the dildo, and the deceased DNA is not on it. So that's something you'll have to take into consideration. You're going to hear from Sergeant Kirk Brester from the Green Bay Police Department. He was dispatched to 829 Stony Brook Lane regarding a suspicious situation on February 23rd, 2022. And that he conferred with Officer Wanish outside, that he had contact with Tara Pakinich and Stephen Hendricks, and that he did a protective sweep of the residence, and they didn't find anybody else other than Ava Wheelock, who was the young lady, she's 16, sleeping in a bedroom. You're going to hear from, I believe, Officer TJ Buckman, that he arrived on the scene as a supervisor to this apartment complex. And he actually went to 2353 Eastman Avenue in Green Bay. And he saw that gold van parked outside, and he had several other officers keep the van under surveillance. And at least from his initial investigation, he did not have enough information to determine whether or not Taylor Schabusiness was the suspect or the victim. And so those are some other things that you're going to have to take a look at and think about. You're going to see the videotape in this case, where there's a lengthy video down at the Green Bay Police Department between Detective Groff and Detective Kempf and my client, Taylor Denise Schabusiness. And they talked, and Detective Groff asked her lots of questions about what she knew and her whereabouts and what may or may not have happened. So you have to pay close attention to that and think about the things that are said. In a case like this, and really in any case, you have to assess the credibility of each and every witness. You have to take all of that into consideration in this matter.
So like that's when she confessed. So what was he trying to say? That the cops, is it like a coerced confession, or her credibility? Maybe they're talking about her, that she was incapacitated or on drugs or something, or blacked out or whatever. I'm not really following. He's like, make sure you listen closely to what was said. It's like, do you want him to listen closely to what was said? Because it's not good for your client. And we'll wait and talk about that more when it happens. But if he's talking about her credibility and mental capacity, that's not going to be something that he can really argue in this first phase. Now, that being said, there has been mention of meth, that they were taking it, and potentially other drugs and blacking out. There has been discussion about that. I think there will be discussion about that, but that is not a reason to vote for not guilty at this phase of the trial, which is kind of where it gets confusing, but not really when we discuss comparing it to how other states do it.
I'd ask that you, when you're considering all of the evidence, don't jump to conclusions. Don't rush to judgment. Please keep an open mind. Listen to all the facts. Listen to what every witness has to say carefully and weigh what they have to say. And remember, there's always two sides to every story. You jurors are going to have to decipher the facts of what may have occurred, what didn't occur.
So you have to decipher the facts of what did occur, what didn't occur. Don't jump to conclusions. Wait till you hear all the evidence. Again, generic kind of defense arguments we hear all the time, not incredibly connected or specific to this case. So that's the defense kind of set up, and that's exactly how it's gone. The 911 tape, law enforcement officers, witnesses that have been called already. That's basically what he's pointing to, is inconclusive DNA evidence. Taylor Schabusiness wasn't there. It wasn't a van that she owned, but it was owned, of course, by the person that she lived with or shared the apartment with. She was the last person that was seen with him. She had cuts on her hand. She told him where the body parts were. She confessed. So, I mean, a lot of evidence building up against her. A very, very difficult phase one of the trial. Now, to talk about these two different pleas in two phases of the trial. Most states, like we've talked about, that have a not guilty by reason of insanity defense, the defendant admits that they did it, but it's an affirmative defense. So there's a reason that they did it. They should still be not guilty, like a state like Florida. But even when that happens, or even Letitia Stalk type of deal, even when that happens, the state still takes the time to prove the underlying facts, because they still have to prove that that's what happened. So even if the defendant admits it, they still sometimes fight against it. They still sometimes poke holes. They still sometimes say you can't prove it. But most of the time, it's kind of a weak defense. They don't push really hard. Again, in some of the trials we've watched together, like Letitia Stalk, they didn't go hard at the factual witnesses or the survivors or the family members that found the bodies or whatever it may be. They don't go really hard at that. Well, we're going to see how hard this defense attorney goes at some witnesses. So far, I do not feel like he has gone incredibly hard. It almost feels like they're agreeing with some of these facts, just making the state prove the case. So is it really that different than the first part of a normal trial? Because even in a normal trial where the not guilty by reason of insanity is kind of handled together in one, in this case, they've got to prove it first. Jury's got to come to a verdict, and then they get to the second part. Because as I talked about in other cases, usually you handle all the factual stuff first. Then the defense can bring up the expert doctors, and then in rebuttal, the state can respond with doctors. Or like in Letitia Stock's case, they can prove the facts first, then bring in the doctors, then the defense can respond with doctors, and then they can have rebuttal with more doctors if they want. So in this case, there's just even more of a delineation. But what's also interesting in this case is when there is a not guilty by reason of insanity defense, the defense actually has the burden to prove with reasonable certainty by the greater weight of the evidence. So that's the burden the defense has to prove, that the defendant was in fact insane at the time of the crime. And so that's kind of interesting. And people argue about, is that constitutional that the defendant has any burden at all? Well, I think how they get around that is the state first proved that your client did this. So the state has held their burden. If we get to phase 2, that obviously means she was guilty in phase 1. So they have this whole trial first, prove all the facts. If she's guilty, then they go to phase 2. And now the defense has the burden to prove that she was insane. They have to prove by reasonable certainty, by a greater weight of the evidence, meaning the jury has to be pretty certain by the greater weight of the evidence. These words are sometimes hard to understand and give illustrations for, but the greater weight of the evidence is really just 50.1. That is a greater weight than 49.9, right? Even 50.01. That is the greater weight, but then they throw in the reasonably certain language. So that kind of seems like different than the greater weight of the evidence, but somehow a jury's got to figure out what that means with the help of the lawyers. Can they get there? And that phase of the trial is where they're going to talk about mental disorders, mental incapacity, maybe some drug use. And the defense is going to be able, or the state is going to be able to respond then and discuss what their doctors say. Now, I've never seen a trial like this take place. I don't know if the defense goes first because they have the burden, if they go first and last and it switches like that. So I'm interested to see that. But it really is not so uncommon or unlike a trial in Florida where the state proves the case, then the defense brings up the doctors, then the state brings up their doctors in response. It's not a huge difference from that for all intents and purposes, but procedurally it's very different because the jury's got to deliberate. So they learn what that deliberation process is like, knowing that there's going to be a second phase, knowing that they have to keep that out of their mind during this case because they know there are 2 phases. The jury knows there are 2 phases when they start this first phase. So when they come up with guilty, they know there's going to be a second trial because it's the same jury for both trials. Same jury for both trials, unless there's some kind of a mistrial in the second trial or they've got to dismiss a juror or jury in its entirety in that second trial. I would think they keep the alternates around, but I'm not really positive. That would be interesting. I don't know how that would work. Maybe it's in this rule because I have the rule here that I figured we could take a look at together. Explaining this a little bit better in Wisconsin and how they do it. So if you can't read it, I'm going to read it all. Trial of actions upon plea of not guilty by reason of mental disease or defect. If a defendant couples a plea of not guilty with a plea of not guilty by reason of insanity or reason of mental disease or defect, here we go. It's exactly what we have here. There shall be a separation of the issue with a sequential order of proof in a continuous trial. The plea of not guilty shall be determined first, and the plea of not guilty by reason of insanity or defect shall be determined second. So that's what we have here. That's exactly what's happening. The only difference is in like a Florida case is we don't wait for the jury's decision. It's almost like we get it. The defendant did it. Now let's get to insanity. Here, the jury has to agree with the state that the defendant did in fact commit this crime. If the plea of not guilty is tried to a jury, the jury shall be informed of the 2 pleas and that a verdict will be taken upon the plea of not guilty before the introduction of the evidence on the plea of not guilty by reason of mental disease or defect. No verdict on the first plea may be valid or received unless agreed to by all jurors. So it has to be unanimous on the guilty verdict in the first phase. If both pleas are tried to a jury, the jury shall be the same. So it's the same jury handling both of these sections. Unless, or except that, If one or more jurors who participated in determining the first plea becomes unable to serve, the remaining jurors shall determine the second plea. If the jury is discharged prior to reaching a verdict on the second plea, meaning like a mistrial of some sort, the first verdict doesn't necessarily go away. They just have to pick a second verdict, probably tell them that she was already guilty of committing the charge, and they are just hearing the insanity plea evidence. So that's probably how they had to do it. It'd be kind of a mess the second time. The defendant shall not solely on that account be entitled to a redetermination of the first plea, and a different jury may be selected to determine the second plea only. There you go. If an appellate court reverses a judgment as to the second plea, but not as to the first plea, and remands for further proceedings, or if the trial court vacates the judgment as to the second plea, but not as to the first plea, the second plea may be determined by a different jury selected for this purpose. So if the first plea, or if the second plea gets thrown out for whatever reason by an appellate court, trial court, but not the first plea, the first phase, then that first phase still stands. That guilty verdict still stands, and they just try the second phase. So if something like that doesn't happen, then the same jury has to make these two determinations. If the plea of not guilty by reason of mental disease or defect is tried to a jury, the court shall inform the jury that the effect of a verdict of not guilty by reason of mental disease or defect is that, in lieu of a criminal sentence or probation, the defendant will be committed to the custody of the Department of Health Services and will be placed in an appropriate institution unless the court determines that the defendant would not pose a danger to himself or herself or to others if released under the conditions ordered by the court. No verdict on the plea of not guilty by reason of mental disease or defect may be valid or received unless agreed to by at least 5/6 of the jurors. So 10 out of 12. Or if there's less jurors, it has to be at least 5/6. So it does not have to be unanimous for the second phase where the defendant has the burden and is trying to prove that they are, in fact, not guilty by reason of insanity. So I'm looking at my screen. It doesn't look like you guys can read this at all, so I apologize about that. If you want to look it up yourself, it's section 971.165, trial of actions upon a plea of not guilty by reason of mental defect or disease. So guilt phase, unanimous, 12 out of 12. But the not guilty by reason of insanity phase, where the defendant has the burden by the greater weight of the evidence, 5/6. So it drops a little bit, gives the defendant more of a chance because we want to be sure we are not committing an insane person or somebody that was insane at the time of the crime. Additionally, what I think was important is when looking at a mental disease or defect defense, it's important that the jury doesn't think if we come to a not guilty verdict here, they just get to go home free. Instead, they tell them they are going to be committed to a mental institution, a state hospital, until the judge determines that they are not a danger to themselves or anyone else in the public. So that is incredibly important because I think a lot of jurors may think, we don't want this person to go free. We have just agreed that they committed this heinous act or acts. So now we're going to let them go free? No way. So it's important to take that out of their mind. So the jury is involved and understands what's going on with a lot of this process. They know there's going to be two trials. They know there's going to be two verdicts, and they know that even if they're not guilty by reason of insanity, they're committed to a mental institution. I think that's important. I think that's good for a fair trial. If a defendant is not found not guilty by reason of mental disease or defect, the court shall enter a judgment of conviction and shall either impose or withhold sentence under a different section. If a defendant is found not guilty by reason of mental disease or defect, the court shall enter a judgment of not guilty by reason of mental disease or defect. So that first verdict is kind of just like they were guilty, but they're actually not guilty, which is why I think it makes it more confusing than how Florida does it, for example, where we kind of try it all together, but the state proves the facts. The defense brings up and proves that they were mentally insane at the time, and there at least presents some evidence that they were incapacitated at the time or insane at the time. And then the state responds, and the jury takes all of that into consideration and says, are they not guilty by reason of insanity? Meaning we kind of all agree they did it. The court shall thereupon proceed under this section. A judgment entered under this paragraph is interlocutory to the commitment order entered under this section and reviewable upon appeal therefrom. Okay. So that is the full explanation as to what is going on here with the two separate phases, the two separate pleas, how it works, what the jury has to determine, what the jury knows, how we think the defense is going to handle this guilt phase. I think it's going to be a lot of the same, not a lot of pushback. He'll do his best to say, oh, was she even there? How do you know it was her? That We can't really believe that confession because of her mental capacity at the time or whatever it may be. But I don't think it's going to be a winning effort. I think she's probably going to get convicted in this first phase, and then we will leave it open to what happens in that not guilty by reason of insanity. What will the experts say? It's going to be a battle of the experts. We know they were on drugs. Voluntary drug ingestion is not enough for a not guilty by reason of insanity plea. Now, a lot of drug abuse can affect your brain, obviously. You can have defects or diseases because of drug use over time that can potentially aid in a insanity defense. But taking drugs that night on its own and choosing to, which it seems like is what happened here, and then some foul play, things went too far, and she made whatever decisions she made. That is not going to be enough for an insanity plea, but it can be part of it and mixed into the conversation and testimony. So let me know if I answered your question, because so many of you wrote to me on social media, Instagram, Twitter, @Tragos Law. Right here is our handle if you want to follow me on there. So I want to do this video, give a little trial recap, but really focus in on those questions. Hopefully I was able to answer them. If you have more questions, throw them in the comment and give me a like, hit that thumbs up button on your way out. That's all we got for Taylor Schabusiness today, but maybe we'll have some more in the future if you all are interested in it, which you can let me know in the comments and by liking the video. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok @Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.